House Judiciary Committee will come to order. Would the clerk please take attendance?
Chairman Runstead.
Here.
Representatives Tice.
Here.
Howrlap. Here. Cole.
Here.
Hornberger.
Here.
LaFave.
Here.
Greimel.
Here.
Robinson. Guerra.
Here.
Sowerby.
Here.
Mr. Chair, a quorum of the committee is present.
Thank you, and I would like to make an announcement. There is no standing room available in the committee room, so those who are standing who are not part of the media proceed, please, to the overflow rooms down the hall, which are 308 and 307 down the hallway. And this afternoon, we are going to be taking up House Bills 4416, 4417, 4418, and 4419. And I would like to welcome Representatives Hoyniga, Hornberger, Aller, and Cole. Please come up when ready. And would also ask that Tom Lambert, if he is not in the room, come down here to the committee room. Thank you. I think we have the order established in terms of speaking, and if you need to move in front of the microphone to make sure you're heard, that's probably the best way to proceed. But with that, go right ahead.
Thank you, Mr. Chairman and members of the committee. I am here to speak on this package of bills, HB 4416 through 4419, from my extensive personal experience. I am a woman who carries a firearm every day for self-protection. I travel alone, and knowing that my firearm is within grasp allows me peace of mind. I take my Second Amendment right to bear arms seriously. First, I would like to inform those of you in this forum who may or may not already know. It is currently legal in the state of Michigan for a law-abiding person to openly carry a firearm on their person without any training, classes, fees, and state bureaucracy. Again, I would like to repeat, it is already legal in the state of Michigan to open carry a firearm on their person without any training, classes, fees, and state bureaucracy. It only becomes illegal when a person puts on a coat because the gun then becomes concealed. 1 millimeter of clothing makes a difference between a criminal act and a legal act. My question is, why are law-abiding citizens paying expensive fees for courses and permits to exercise their constitutional right to bear arms? We already know criminals are not paying fees, taking classes, and waiting for approvals to come in the mail. My bill, HB 4416, simply amends the penal code to allow a person to carry a concealed firearm without a concealed pistol license. More specifically, it eliminates the criminal penalty for carrying without a permit. This is the important part. I would ask everyone who is against this bill to really listen to this part. I respectfully ask each committee member to support our Constitution by supporting this bill. Women, elderly, vulnerable, and economically disadvantaged people should not be excluded from concealed carry because they can't afford the fees associated with the permit process. Our Second Amendment should not be used as a money grab for permit fees. Please know I am an advocate for education. This bill does not eliminate background checks at the time of a purchase or gun-free zones. It eliminates CPL classes for those who choose to take the course. It does not eliminate CPL classes for those who choose to take the course, especially in cases for state-to-state reciprocity. However, it does give law-abiding citizens the choice. Lastly, one statistic that it is important to remember. The number of people carrying for self-defense contributes to fewer violent crimes in our state. Thank you.
Thank you, and I'd like to move right along with each one of our speakers before we take questions from the committee.
Thank you, Mr. Chair. My bill, HB 4417, simply modifies the Firearms Act of 1927, PA 372, and it removes the references to repeal sections and makes technical updates on 4416.
Thank you, Mr. Chair. My bill, House Bill 4418, modifies the Natural Resources and Protection Act to allow concealed carry without a permit while in a field where there's wildlife. This would not prevent a DNR officer from prosecuting a person for hunting without a license or out of season.
Again, thank you, Mr. Chair and members of the committee, for our opportunity to present this package of legislation. To reiterate some of the things that have been mentioned here, this package of bills would remove the coat tax on legal, law-abiding citizens and their right to carry a firearm if they're legally allowed to possess that firearm. These bills are an incremental step towards reforming Michigan's firearm laws to ensure that law-abiding citizens are not unfairly restricted or prosecuted, even if they have a coat on. It comes down to the fact that you're either a legal, law-abiding gun owner or you're not. I want to reiterate, this legislation does not remove the requirement that a person get a background check to purchase a handgun. A person who is prohibited from possessing a firearm under state or federal law would not be allowed to carry under these bills. They're not allowed to possess, so they are not allowed to carry. This legislation does not make changes in law to no carry zones. A CPL would still be required to carry openly in these zones. CPL training would be optional, and consumer demand for training increases in states with optional licensure programs. More people that can carry, there's more people that want to take classes and be informed and up to date on current firearm laws and regulations. This legislation also would keep the concealed carry permitting structure in place. Number one, to have reciprocity, like Rep. Poitinga mentioned, you need to have a Michigan CPL. And that's going to be very important. I really personally believe that we're going to see an increase in CPLs as more people are actually carrying, because they're going to want that opportunity as they cross state lines. And Michigan is, I believe, has a reciprocity in at least 40 states, one of the highest because of our CPL training classes. And again, it doesn't change those things. So specifically, my bill, HB 4419, deletes the 4-year sentence for unlawful possession of a pistol by a licensee at 750.227A. It leaves in place the penalty for carrying a dangerous weapon concealed. However, the penalty no longer applies to a person legally carrying a pistol. Again, thank you very much for allowing me the privilege and all of us to testify on this package of legislation, and we're happy to take questions.
Thank you, and I would ask the committee to keep the questions very pointed. We have a big stack of people that want to testify, and you'll probably have more questions, so please keep the questions very pointed. And with that, I'd like to start with Representative Greimel.
Thank you very much, Mr. Chair, and thank you all for your testimony. I appreciate you being here today. I've got a couple questions, if the chair will allow it. One is regarding some of your comments, Representative Hotanga. You had indicated that you encourage us to support the Constitution by supporting this bill. Is it your belief that current law violates the Constitution in some way? And if so, why haven't courts overturned the current law as being unconstitutional?
Did you want to come up and say anything? Okay. If we can ask Mr. Lambert to come up too, but it is my feeling that it is unconstitutional. If you have a person who is financially strapped and cannot afford to take the classes, the permitting, you have to get recertified every 3 years, it's expensive. And those people who are disadvantaged economically should be afforded the right to carry, should not be denied their right. And I believe it is a constitutional right, absolutely.
And the second part of the question, why haven't courts then overturned the existing law if it is in fact unconstitutional?
I couldn't answer that.
I'm also curious, if these bills are passed into law, will those carrying concealed firearms still be required to disclose that to law enforcement personnel if, for example, they're stopped as part of a traffic stop and law enforcement personnel approaches the vehicle?
I would highly recommend anybody with a firearm in their car to let the police know when they're approaching that they do have a concealed permit or that there is a firearm. I would encourage that of anyone driving.
Well, I'm not asking about your personal recommendations. I'm asking if
It
these
is
bills
law.
pass into law, will in fact the law still require people to disclose that they have a concealed firearm on them?
Yes, yes, it does. And that is the law, to disclose your firearm when it's in your car. Absolutely.
And my final question, Mr. Chair, if you'll allow me.
Make it very quick.
My understanding is that under existing law, there are some offenses that disqualify someone from some criminal offenses, convictions, that prohibit someone from carrying a concealed firearm. There are other criminal offenses that don't prohibit carrying a concealed firearm under current law. Currently, if a law enforcement officer comes across someone who is carrying a concealed firearm, they can easily determine whether or not that person is authorized to do so by determining if they have a permit to do so. If this law were to pass, a law enforcement personnel officer wouldn't have that ability to determine whether or not the person is legally authorized or prohibited to carry the firearm. So the only way that they could determine that, presumably, is if they knew off the top of their head all of the different convictions that prohibit someone from carrying a concealed firearm. How is it realistic to assume that law enforcement personnel will know all of the offenses that do prohibit carrying a concealed firearm and all the offenses that won't?
I don't want to speak on behalf of law enforcement, but do one of you guys want to speak on that?
Open carry currently is the same exact way.
Right. Well, that's what I was going to say, but currently, and as I said in the beginning, this is already taking place. Open carry is the same way. So that's the most important part of this whole thing, is that, you know, I didn't want to come in here with my gun on me, so I have it in my purse, but I was going to come in here and show you. Anyone without the background checks can already carry, so it's no different. The only thing that is making it different is this 1 millimeter piece of clothing. And people are so confused by the Michigan laws as they stand right now that this will clarify. People are currently getting criminal records because they are so confused. They're inadvertently covering their firearms and they don't know the difference. And these are good people that are getting criminal records. So it's no different than it's already standing with open carry.
Well, in regard to my question, though, in terms of carrying a concealed weapon,
Correct.
how is a law enforcement officer who comes across someone carrying a concealed weapon to know if they're legally authorized to do so or not? If these bills pass?
Right, well, again, I'm going to revert back. How would they know during open carry? How would they know? It's no different.
Well, I understand, but is your concern that there's inconsistency between open carry and concealed carry laws? And if so, would you be open to changing open carry laws to be in line with concealed carry laws?
Well, we can do it that way. I mean,
So you would be okay with that?
I just, the question is kind of redundant because already what you're describing is already taking place. Anyone in this room here today can openly carry. If they go and purchase a gun and do the background check, they can openly carry.
One final question, Mr. Chair. Circling back to my earlier question about whether a person carrying a concealed firearm is required to disclose. I understand that under existing law, there are very specific penalties for failure to disclose, namely that the person is then prohibited from carrying a concealed firearm with the first offense for a period of 6 months, I believe, and on the second offense for in perpetuity, in essence. So there's a very clear penalty for failure to disclose to law enforcement currently. My understanding of these bills is that that provision, that enforcement penalty, is not present. Is that accurate?
Thank you for making my point. Thank you. Why are law-abiding citizens held to a stricter amount of rules than, you just made my point, sir.
Well, let me
So you're being
rephrase.
held, just because you're putting your jacket on, you're being held to a stricter guideline of rules. And law-abiding citizens should not be held to stricter guidelines.
Well, my view is that individuals should be required to disclose whether they carry a concealed firearm to
Absolutely.
law enforcement, and it sounds like you agree with that.
Absolutely.
What I'm simply pointing out is that the enforcement penalties to enforce that law would be stripped out of the law if these bills passed. And for those of us like you and I who believe that people should be required to disclose a concealed firearm to law enforcement if they come across law enforcement interaction, I would think you'd be concerned about the elimination of those penalties and enforcement mechanism.
I just, again, I'm going to resort back to, we already have open carry. This is already taking place. The police, the law enforcement are already dealing with us.
Okay,
Currently.
we do have to move on to Representative LaFave.
Mr. Chairman, through you to Representative Greimel, is it your opinion that people do not have the right to remain silent when they are pulled over by a police officer? And with that, I respectfully.
Good point.
Okay, we will go next to Representative Guerrero.
Thank you, Mr. Chair. It sounds like there are two main arguments, and one is the constitutional factor, which, of course, the courts have not yet ruled on, but the other is a financial hardship. So I guess would the sponsors be open to just eliminating the fee? Because I guess as someone, I've gone through the CPL training because my intent is to use a gun. My fiance has them, but I didn't purchase them. But I thought the training was really important because I did not grow up around guns. So for me, it was really important for me to get more comfortable with them. And I understand that obviously people would still have that choice, but not everyone will make that choice. But I think by eliminating the fee, we could encourage people to do that without putting this financial hardship on them. And so I'm curious as to what your thoughts are on just eliminating the fee. Obviously, the MSP would probably have some issues because of the fees that they collect. Hopefully, we'd address that separately. But that seems like that would get to your other main argument is the financial hardship part.
I think it would be hard to find a concealed carry class that would do it for free. Most of them are charging $100 to $200 to $300, and then you go in, it's over $100 to get the permit at the courthouse, and that is every 3 years. People just simply cannot afford it. But you did make another good point. Did you know that if you have a CPL and your husband does not, and that gun is in your car, and you did get pulled over, that one of you are going to be in trouble without the CPL? This will eliminate so much of those headaches. A lot of husband and wives, one has a CPL and the other doesn't, the other spouse doesn't. And we have cases where people are getting in trouble for this. And so, thank you for your question.
Thank you, and we're going to give one more question to Representative Greimel.
Thank you for your indulgence, Mr. Chair. I know that time's of the essence here, so I appreciate the time. Just one other point or question. When I asked about the requirement of disclosure to law enforcement and the penalties that exist in current law for failure to disclose, and the fact that these bills would eliminate that penalty, your response was we're already doing that for open carry. I ask you to explain that in light of the fact that with open carry, no disclosure is necessary since the firearm is not concealed, so the law enforcement officer can readily see the firearm in that case. So there's no need to even have such a requirement, much less enforcement for that requirement of disclosure. In the case of a concealed firearm, there is a need for disclosure if law enforcement is to know somebody has a firearm on them. And in order to make that requirement meaningful, we need enforcement mechanisms. So I don't really understand your explanation earlier of saying that we do it for open carry. Can you expand on that?
I would just say, are criminals abiding by these laws? Are criminals letting the police know that they're carrying? I can't, I'm sorry, again, it's a repetitive question. I just think that the law enforcement, either a criminal or a law-abiding citizen is being pulled over or being questioned, they're either going to be truthful or they're not. So they're either going to be doing criminal activity or they're not. The first thing I do, it's just common sense. If a police pulls me over and asks me, are you carrying a gun, I better be truthful. As a law-abiding citizen, I better be truthful with my police.
Thank you very much. And if there is no, Representative Robinson.
The criminal statute for carrying in a vehicle, the element of concealment is not an issue. Do you know that?
It is an issue.
No, it's not an element of the crime, concealment, for carrying a gun in a car, for that penalty under that statute. It's the issue of concealment is on person as one of the elements of the crime. I just want to let you know that.
Yes.
And the other thing is, many times, is there any proposed remedial legislation for those individuals who have been previously convicted of carrying a concealed weapon? Is there anything in the works on that? So that if this passes, those individuals who have been convicted of CCW, is there any way we can open up their cases? And you know, like you say, innocent people who just happen to partially conceal the weapon. Mm-hmm. As you say, under the carrying concealed weapon, it's only partial concealment, like you say, a little bit of the coat or in a holster or whatever. So have you thought about that, giving a break to those innocently convicted individuals? Because I know many who now are deemed criminals, and they had guns for self-protection. But is there anything in the works, do you know?
I do not know.
Thank you.
Okay, next is Representative Howerlick.
Thank you. I think that's a good point. I would hope that would get some consideration. The question I have for you is, I will tell you, I've long had some frustration with the definition of concealed carry, insofar as if only a small portion of the gun is concealed, even inadvertently, it's considered concealed carry. I think you make a good point with the issue of husband and wife. One has one is licensed and one isn't, and they're transporting a weapon. I guess the question I have for you, though, is should we address those issues narrowly? Because I think there's some very legitimate points there. Or should we do the repealing sections like we're doing in these bills?
I absolutely believe we should be repealing these. This has been done in 13 other states, and nothing bad has happened. All the headlines with all the horrible things that are going to happen if we do this are false. And the false narrative is being used to scare people. 13 other states have done this, and there's no explosion of crime. There's nothing statistically happening that is harming the people any different than what happened before the permit process.
Remember, Representative, that Vermont has always had constitutional carry, and the sky hasn't fallen in Vermont. So the freedoms have always been there in that state. And that if these laws were in place right now, the partial concealment convictions would not be an issue.
Thank you. Is there any other questions from the committee? Seeing none, thank you, sponsors, for your testimony. And I would like to call up
so much.
Tom Lambert from Michigan Open Carry.
Trying to keep track of these as we go through them.
Yeah.
Members of the committee,
I'd also like to notify David Heller of the Fraternal Order of Police, if he is in one of the rooms, to make his way to the committee room. And I know Tom Lambert has some areas of expertise that maybe could shed a light maybe on a few of the other questions that were asked, but go right ahead.
Mr. Chairman, members of the committee, thank you very much for the opportunity to speak in this legislation today. As mentioned, my name is Tom Lambert. I'm the President and Legislative Director of Michigan Open Carry. It was hit on a few times, but I really want to reiterate, first of all, what these bills do not do. These bills do not change the current purchasing process for a pistol. For 90 years, Michigan has had the effect of universal background checks when it comes to pistols. These bills do not change that at all. The other thing these bills do not change is a list of restricted zones. We have many different sections that restrict firearm possession in different manners. These bills do not change any of those zones. Leading up to this meeting, I've seen in different places some saying of this legislation fits into a guns everywhere for everyone type of extremist agenda. Well, as we've specified, this doesn't change who can have a firearm, nor does it change where they can carry it, so I fail to see how that type of saying is little more than a relevant hyperbole. But let's talk about what this legislation does do, specifically for some of my members that openly carry. There's two specific things it allows them to do. The first one is it allows them to carry a concealed pistol without a concealed pistol license. Where that is relevant to them is if they're walking around, they no longer have to fear the very extreme felony for accidentally concealing their firearm or part of their firearm. And in this state, where we have many cold months, wearing a coat is very pertinent. Some of my members have resulted to wearing what's called a drop leg holster. That moves the firearm from your hip down your leg to roughly your thigh area. What that does is it takes the firearm and moves it out from underneath your coat. Unfortunately, some members of law enforcement and some members of the public that don't really understand what they're seeing, they look at that as a tactical style or method of carry. And one person, a number of years ago in Grand Rapids, was detained and proned out at gunpoint, handcuffed, all his belongings taken, and the officer berated him for a long time, even though what he did was entirely lawful. The next thing this does for somebody who wishes to openly carry without a CPL is it allows them to get in their vehicle. Again, Michigan's statute is very broad in how it treats concealed pistols, and it is very, very harsh. We are talking about a 5-year felony. In order for somebody to openly carry their pistol beyond walking distance of their home, they have to transport that pistol. And Mr. Chair, with your permission, I'd like to demonstrate that process, what somebody would currently have to go through to transport their pistol.
And you have an example of a pistol?
I do, sir.
And that was checked by security and
Yes, sir.
and the sergeants, and they notified me, so yes.
Here with me today, I have a pistol in this case. There is no live ammunition in this case. As mentioned, the security officer did check it. What you'll see here, these are called dummy rounds. They're for demonstration purposes only. So, what someone has to go through, if they are openly carrying without a CPL, they drive to where they need to go, they go open their trunk, or first the transport criteria. In order to transport your pistol currently, it has to be unloaded in a case designed for the storage of firearms, and it must be in your trunk. So when you drive somewhere, you get out of your vehicle, you open your trunk up, you take your case out of that trunk. This must be out of your trunk. You cannot do this in your trunk. Take the case, set it on your car, open it up. You then take the pistol out of the case, take the magazine, insert it into the firearm, chamber around, put that pistol in your holster, close the case, put the case back in your trunk, close your trunk, and be on your way. Then when you're done doing whatever you need to do, you come back to your car, you open your trunk back up, get that pistol back out of, or get that case out of your trunk, put it on your car. Again, this cannot be done in your trunk. Open the case up. At that point in time, you grab a hold of your firearm, take it out of your holster. Again, this would be a live firearm at that time, loaded. You would take the magazine out of the firearm, you take the round out of the chamber, Put the pistol in the case, load that round back into your magazine so it's not rattling everywhere. Close the case, put the case back in your trunk, and be on your way. Now, if any of you perhaps felt uncomfortable during that process, I do apologize, but that is nonetheless the process somebody has to go through to transport their pistol today if they do not have a CPL. Now imagine what that's like in a crowded parking lot, at a fair, at a restaurant. Imagine what that's like for somebody who doesn't understand what's going on, what they see. A number of years ago, one of my members was in a crowded parking lot and was worried about somebody interpreting that the wrong way. So they opened their driver's side door up, sat down in their car so they could do it in their driver's seat with their feet still outside. An officer saw that, charged him with a felony. The other portion of that is what we call accidental or negligent discharges. Whether you're in the military, whether you're in law enforcement, whether you're a citizen caring for your own self-protection, the vast majority of accidental or negligent discharges happen when somebody is handling their firearm, whether they're taking it out of their holster or putting it back into their holster. Again, it doesn't matter who you are, how much experience you've had, that's when they occur. I'm sure you understand, many of you have a lot of experience with very well-intentioned laws that often produce a result that perhaps was not intended. I would suggest to you that this is one of those laws that has produced a result that was not intended. It requires law-abiding people that have gone through the background checks to handle their firearms more than needed. A lot of holsters today are designed, including the one I'm wearing today, so I could take the holster off my body without removing the pistol from the holster. Ideally, that pistol should never come out of the holster except in cases of emergency. But as I said, unfortunately, our law requires them to handle it.
I think we're going to have to move to questions here real soon.
I have about 10 seconds left.
Okay.
The reason why we support this legislation is it allows people to carry in the manner they choose. Law-abiding citizens carry in the manner they choose that's best for their specific situation, not anyone else. And the last thing I would suggest to you is, in my opinion, it is only a matter of time for this legislation. If you look nationally, I think whether it's today, whether it's next year, whether it's 10 years from now, it is only a matter of time for this legislation. May I answer a few of the questions that were brought up previously?
Let's see if there's time
Sure.
when we get to the end. They may ask similar types of
With that, I
questions.
thank you very much for your time.
Representative Grimel.
Yeah, thank you very much for your testimony. I appreciate you being here. If those who carry openly don't want to have to store their firearm in the prescribed manner in the trunk and load it upon leaving their vehicle and unload it upon returning to their vehicle, why not just get a permit? Is it just the fee for the training course that is the concern, or is there some other concern going on here? I don't fully understand. It doesn't seem like a very onerous process that we have now for those who want to carry concealed. They can get a permit. And, you know, we are now a shall-issue state. I voted for the legislation to make us a shall-issue state, so we have consistency statewide so that we don't have local gun boards making arbitrary decisions. Why isn't the existing system adequate? I don't understand.
Wonderful question, Representative. Thank you very much for that question. The answer varies from person to person. Both cases that I listed, the person that was proned out at gunpoint and the person that sat in the driver's seat of his vehicle, both of those cases at the time actually had their applications for a CPL in. They were waiting on the state to respond to them. Nonetheless, they still went through what they did, and the one was charged with a felony. Luckily, the prosecutor worked with him and pled it down to a misdemeanor, but then he was then precluded from having a CPL for 5 years after that. He tried to do something right, and he found himself precluded from getting a CPL for 5 years after that. That was one reason in his case that he had to then do this for 5 more years after that. For some people, a $115 fee, I'm a white guy from Kent County. I'll be honest with you, it's not as big of a deal for me that it is for other people in disadvantaged areas. Oftentimes we find that the people that need to defend themselves the most are the least likely to be able to, 1, pay the fee, and 2, find the time to get that training that's required. If we can at least allow them to start to do what they need to do in extreme scenarios. What we found in other states is once they get into that, they're more likely to seek the training, they're more likely to seek the rest of the process afterwards. And then that's on one end of the spectrum. And the other end of the spectrum is flat out, I do have people that have told me they don't want a government license, and it's their decision to make.
Well, I want to follow up on one of your earlier comments as well. I want to make sure that I understand your testimony. You had said earlier that there's nothing about this legislation that changes who can buy a gun or own a gun, I believe.
Correct. A pistol.
Which I agree with. But it does change, I believe, I want to ask you your opinion, I believe that it changes who can legally carry in a concealed way. Other than just the absence of the need to get a license, I believe that the prohibited criminal convictions are modified in terms of who would be allowed to carry in a concealed fashion based on some convictions as opposed to under current law. Do you agree with that?
Yes and no. It would allow somebody to carry a concealed pistol without a license everywhere where they can currently openly carry without a CPL. Some of your questions that you brought up before about where they're prohibited to actually carry, there are numerous areas that currently today you can carry a concealed pistol without a license. Your own home,
Yep.
your place of business, and other land that you possess. You do not need a license to carry there.
Understood.
So if a law enforcement officer comes up to you and you're carrying a concealed pistol in any of those places, you don't have to have a license to carry any of those places.
Understood.
Okay.
My question is this. Isn't it true that under current law, there are people who have been convicted of certain crimes who are not allowed to get a concealed pistol license because of those convictions? And for some of those convictions, those people, if this law were to pass, would be allowed to carry in a concealed manner.
It is true that we do have, I believe it's about 70 misdemeanor disqualifications to get a CPL. Those people would be able to carry in a very limited manner. As I mentioned, they would be able to conceal anywhere that they currently can openly carry without a CPL. But to give you the nature of what those types of misdemeanors are, I'd suggest to you that if we applied that same set of misdemeanors, and heck, if we do it this way, if we required every member of law enforcement to get a CPL or to be eligible to get a CPL in order to be employed as a law enforcement officer, we would have a lot of fired law enforcement officers in this state.
Well, some of those...
They can carry everywhere currently. There's no restrictions to them. And the training requirements from a CPL holder to a member of law enforcement are not the same. They're actually somewhat less for law enforcement. The criminal disqualifiers for members of law enforcement are not the same. The criminal disqualifiers for CPL applicants is way higher than it is for members of law enforcement, yet members of law enforcement have far more ability to carry than CPL holders do.
Well, let me ask a more pointed question. I'm not terribly interested in the comparison with law enforcement officers and their ability to carry, because obviously they receive very rigorous training.
Not always true.
And, well, if they're MCOL certified, they receive very rigorous training.
The range portion of that is, forgive me for interrupting, the range portion of that, we FOIA'd it, is 25 rounds to qualify. State law mandates a minimum of 30 rounds for a CPL applicant. I'm an instructor, all of my students shoot at least 100.
But in any event, if these bills pass, law enforcement officers will be required to go through much greater training than the people who this bill would allow to carry in a concealed fashion, because in fact, this bill would eliminate any requirement for any training for anybody who carries a concealed firearm. But that's not really my question or point. This is my question and point, which is some of the misdemeanors that we're talking about include some sex crimes, some stalker offenses, and in fact, currently, those who have a PPO taken out against them cannot acquire a concealed pistol license, but this legislation would allow those who have a personal protection order against them to carry a concealed firearm, correct?
Not necessarily. Some of the things you mentioned are disqualifiers for possessing a firearm currently.
Well, currently, yes, but not all of them. There are crimes that fall into the categories that I just mentioned that are not disqualifiers, that rather are disqualifiers currently to carry a concealed firearm.
Get a concealed pistol, to apply for a concealed
Yes,
pistol license.
that would no longer be disqualifiers for someone to carry a concealed firearm, correct?
To apply for a concealed pistol license.
Yeah, which means to legally carry a concealed firearm.
Outside of the zones where you can already do it without a license.
Exactly. And in regard to my PPO question, it is true, isn't it, that currently those with a PPO against them cannot get a concealed pistol license. And this law would change the law so that they could carry a concealed firearm anywhere.
No. Those with a PPO against them with a certain provision prohibiting them from having firearms, they would be prohibited from getting the CPL. And you tacked on an anywhere onto the end of there, again, this legislation does not change the already long list of restricted zones.
Your last point is fair, but this would greatly expand the areas where people with PPOs against them could carry concealed firearms.
If you tack on that firearm provision of the PPO, that's the only thing that's relevant, and it expands nothing for that case.
So your assertion is that currently it's only PPOs that have that firearm provision that prevent somebody from getting a CPL?
That is correct. And not only that, it must be, it can't be an ex parte PPO.
But is it your view that those people who have those exact same PPOs against them, if these bills pass, will still not be able to carry a concealed firearm?
And in that case, they're prohibited from possessing firearms as part of the PPO. So we're not even talking about open carry in that situation because they're, again, prohibited possessing firearms as part of the PPO. No open carry, no concealed carry.
Well, what I'm saying is, what if the PPO doesn't prohibit them from owning a firearm or buying a firearm? What if it simply prohibits them from carrying a concealed firearm?
I'm not aware of a PPO, and somebody please correct me if I'm wrong, that specifically prohibits just concealing a firearm. Usually it is possession of a firearm. Am I incorrect on this? And in that case, if you don't have a CPL, you would not be able to open carry either. And all this legislation does, again, is just bring the concealed carry provisions in line with the current open carry ones for people who do not have a CPL. So it's not like we're entering uncharted grounds here. I think the coat tax title is very relevant. All it really comes down to is allowing someone to put a coat on without getting a government permission slip first.
From what I've heard from our policy lawyer, you are correct.
Thank you.
So, any other questions from the rest of the committee?
I would love to have a question on disclosure, if anyone would like to take one.
This is your chance. This is your opportunity. Representative Lefebvre.
In your opinion, when someone is stopped by law enforcement, do they have a right to remain silent?
In my opinion, absolutely they do. Now, the courts might feel differently than me, but they absolutely do. And here's the interesting thing when it comes to disclosure under our current law. If you read the section, it is 28.425F, Section 5F of the Act, if anyone is interested, and you go down to subsection 3 of that, you'll see that it says anyone licensed under this Act, and then yada, 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 is required to disclose immediately. There's a lot of people that carry in our state that are not licensed under this Act. In fact, they're in this room today. Some liaisons that have a license from another state and live in those states, they do not have to disclose. Only me as a Michigan resident actually licensed under our Act, only I have to disclose. Members of law enforcement, they don't have to disclose. If we look at states around us, 2 of the 3 states that border us have no duty to disclose in their own states, nor do they have to disclose in this state. In Indiana, an 18-year-old can get a lifetime permit with no training whatsoever, and they do not have to disclose in their state, nor do they have to disclose in our state, yet there is no trail of dead bodies coming up I-96. If I would submit to you that disclosure is based on a logical fallacy, plain and simple. If a law enforcement officer walks up to a vehicle, they should automatically assume that person is a danger to them. And that assumption should not change based on words coming out of that person's mouth. I would assume that would be a very dangerous situation, that if all I had to do was say one thing or another, answer no, answer yes, you choose, and I would get the law enforcement officer to drop his guard. Therefore, disclosure is a logical fallacy, which is why most of the states in the nation do not have it.
Thank you. We've got more testimony to get to. I appreciate your time.
Thank you very much for your time.
Next, we have David Hiller of the Fraternal Order of Police.
I would like to clarify an issue that Mr. LaFay raised. The right to remain silent does not trigger, Miranda does not trigger until you're in custodial interrogation. It's television. The cops do not have to advise your Miranda rights when they arrest you.
Thank you.
It's not until you're in custody and interrogated.
You don't have a right to remain silent at
Okay.
all times during the day.
Okay, we got to get back on course here. David Heller, welcome, and proceed.
Thank you, Mr. Chair, and members of the committee. You have a lot to hear today, so I will be brief. The Fraternal Order of Police strongly opposes House Bill 4416 through 19. Make one point very clear. We truly believe in the Second Amendment. That's not the issue. But we also work day after day to provide the safest environment for the communities we serve. And that is an area of concern, we believe, with these particular bills. That being said, the proposed package of bills basically allows anyone to go out, purchase a handgun, and carry it concealed. Interesting enough, I can't carry a dagger concealed, but I can carry a loaded firearm. We find this very troubling. There is no mandated training to carry it concealed. Today, in order to carry concealed, or a CPL, there are a number of steps that you must take. You must be 21 years of age, submit fingerprints, application, mandated training by an NRA or MCO certified instructor. The training teaches far more than just how to shoot a gun. It deals with safe handling, laws pertaining to where you may or may not carry, the type of ammunition you need, the distance your rounds travel, and so on. This is an 8-hour class with a range time. It also includes instruction at a very interesting point, self-defense. And Representative Grimel, it also mandates any stop by police officer, you must identify that you're carrying a weapon. That's part of the CPL license. So to put a firearm in the hands of someone with no required training to us is absolutely absurd. When we talk of safety in our communities, it goes way beyond the person carrying the firearm. It goes to the danger of the others in the community. In March of this year, in 1 week, there were 3 youths shot, 1 fatally. In May of 2016, it was reported that over a period of 17 months, 8 children were either killed or seriously injured with guns. A 5-year-old girl was fatally shot herself when she found grandma's gun under the pillow. These are not drive-by incidents. These are children with availability to reach or to find a gun. You say the main reason for that is gun safety. We agree. But these bills will allow that same individual who didn't take the time to safely secure a weapon, they now have the right to carry it without any training. And we stand absolutely opposed to the legislation.
Thank you. Do we have any questions from the committee? Apparently we do not. Thank you so much for your testimony. And next we have Michael Thade of the Michigan Gun Owners, and on deck, Brendan Beaudrew will be next.
Thank you, Mr. Chair and the committee. Michael Thede from Michigan Gun Owners. I appreciate the time. I've had a concealed pistol license for over 30 years, so I can address the changes that have been made since 2001. These bills would give us back what I had to give up for the state to get shall issue. Back before 2001, I didn't have to have a permit to walk into a school. I didn't have to have a permit to walk into a stadium. I didn't have to have a permit to walk into all of these pistol-free zones. I could do all of those things. And those places weren't any more unsafe. I didn't have to take a class to tell me that I was going to be safer to do all of these things. I didn't have to give the state an extra $105. I didn't have to have an instructor to tell me how to safely do all of these things. And these bills are going to take me back to that place before 2001. I gave up those freedoms that I had so that more people in this state could have a concealed pistol license. Didn't make this state, any more safe. It made it richer. All the drive-by shootings that you just heard about had nothing to do with concealed pistol licenses, had nothing to do with making people safer, had nothing to do with these bills, had nothing to do with children finding grandma's pistol. These bills had nothing to do with those things. It had to do with education, I agree. These bills have nothing to do with that. These bills take us back to what I had to give up so that more people in this state could carry a concealed pistol license. Shall issue didn't give us anything else, but it took away from what I had. So let's give us back what we had before 2001. It's as simple as that. Shall issue didn't make us safer. Thank you for your time.
Thank you. We have a question from Representative Greimel.
Yeah, thank you. I'm trying to reconcile your testimony with some of the testimony we heard earlier. If I'm correct, it sounds, or if I'm understanding you correctly, it sounds like you believe that these bills would eliminate pistol-free zones for those who carry concealed weapons.
No, sir.
When you talk about going back before 2001, help me understand that.
Well, what it does is it takes us back to being able to have a concealed pistol license without having to go through and give the state money, without having to go through and pay for classes that do not make people safer.
Well, why is it that you don't think that gun safety classes would make people conduct themselves in a more safe manner?
Because I believe that people that own guns already are safe gun owners.
Everybody? I mean, surely you agree that there are accidents that occur in homes because of careless people who maintain their firearms in an unsafe manner, no?
Yes, sir. And some of those people are police officers that are already trained. And there are instructors that are already trained. There are negligent people out there that own guns. But they're not because they've gone through gun safety classes.
But doesn't knowledge about how to properly and safely conduct oneself with firearms decrease the likelihood of those dangers?
Not necessarily, as been proven by an instructor just recently in the news that had a negligent firearm accident during a gun safety class.
Okay, we want to keep moving along. Thank you so much for your testimony. I think I would like to hold off on Brendan Boju for this next testimony because I want to kind of have some, if it's okay, I'll hold you off from. I'd like to try to keep it going back and forth. So if I could have, if they are in the room, in the Physicians for Prevention of Gun Violence, that would be Andrew, can't read this, Zwiffler, and also Scott Nichols of Moms Demand Action, if Scott is available. And we also have, with the same organization, Julie Henschel with Moms Demand Action. And Okay. Go right ahead.
My name's Andrews Weifler. I live in Ann Arbor. I'm a physician, specialist in internal medicine with a focus on preventive medicine. I'm retired now. I'm co-founder of Physicians for Prevention of Gun Violence, a statewide organization. And I'm in opposition to HB 4416. Allowing people to carry a concealed handgun with no license, background check, or safety training, as I understand this bill would do, is a prescription for disaster. Simple disagreements over driving etiquette or political preferences can quickly move from insults to gunfire. Additionally, since Michigan is a stand-your-ground state, the use of lethal force is justified outside of the home when there is threat of bodily harm. Given the level of racial tension in society at this time, the perception of a threat can too easily be exaggerated and result in a deadly interaction, particularly when racial difference is involved. In my view, this bill is not only unnecessary, it is dangerous. And I urge you to vote against HB 4416.
Thank you. Next.
Dear Chair Ronstedt and members of the committee, thank you for opportunity allowing me to testify today. My name is Scott Nichols and I live in Clinton County, Michigan. I'm here today representing Moms Demand Action for Gun Sense in America. We're a grassroots movement of Americans committed to fighting common sense policies for policies that respect the Second Amendment while also working to improve public safety. I'm here today to urge your opposition to House Bill 4416. A dangerous bill that would allow people in Michigan, including certain violent criminals, convicted stalkers, to carry hidden loaded handguns in public without a permit or safety training. I'm by no means anti-gun. In fact, I'm a lifetime gun owner. I received my first CCW permit when I was 21 years old. I've been around guns all my life, since an early age, hunting on my family's farm in Clinton County, competing in shooting sports as a youth in 4-H, captain of the MSU rifle team. I'm also a former officer in the United States Army and a retired trooper with the Michigan State Police. But I've also known the pain of gun violence all too well. When I was 12 years old, my uncle killed himself with a handgun in the garage while his wife and daughter were napping. They were the first to find him. Having grown up in Michigan, I understand our culture of responsible gun ownership. Our concealed pistol license has contributed to this culture for nearly a century, helping to ensure that people who carry concealed handguns in public places have firearms safety training, and helping our law enforcement officials prevent dangerous people from carrying concealed handguns in public. But House Bill 4416 flips this culture on its head, lowering the bar for who can carry concealed handguns in public and opening the door for certain convicted criminals to legally carry hidden, loaded handguns in places our families frequent. Under current Michigan law, people recently convicted of stalking, criminal sexual conduct, indecent exposure, certain drug crimes, and more than one drunk driving offense do not qualify to receive concealed pistol licenses. And it works. In the most recent year of data available, the Michigan State Police denied nearly 2,500 concealed pistol licenses to people who were disqualified from obtaining one. 2,500, including felons, domestic abusers, and stalkers. But permitless carry would allow some of these dangerous people to legally carry hidden, loaded handguns throughout the state. This bill would also allow Michiganders with zero firearms training, zero, to carry loaded handguns in public. Currently, Michigan requires at least 8 hours of firearms safety training to obtain a CPL, covering everything from Michigan gun laws to shooting positions. These training requirements are essential to ensure people who carry handguns on our streets and in our businesses understand the responsibility that comes with carrying a concealed weapon in public and have that experience in handling and shooting a firearm. In conclusion, this bill does nothing to increase the safety of Michiganders. It does, however, make the job of Michigan law enforcement harder and weaken the vetting and training process to carry a concealed handgun. I urge you to vote no on House Bill 4416.
Thank you. Representative LaFave.
Thank you both very much for your testimony. You mentioned you were a state trooper?
I retired from the flip post.
Well, I really appreciate your service. Thank you very much. My question is, Whenever were you on road patrol at all?
Yes, so I worked in narcotic teams, and then I also worked half my time on the road, half my time in the detective bureau.
So if you encountered an individual that you came in contact with, say for a speeding violation, and you asked them for their registration, proof of insurance, and they gave you all the documentation, and they refused to speak or say anything at all, were they subject to arrest for failure to speak?
No, it all depends, though, maybe if there's odor of alcohol, if there's odor of marijuana in the car. It all
Sure, but if
depends
you
on
have
what I'm
no
finding.
suspicion of DUI or
Absolutely.
any other
You're
crimes, you have a right to remain silent?
In a custodial arrest, yes.
Thank you.
Thank you. Any other questions? If not, thank you so much for your testimony. I would like to call up Brendan Boju, and on deck to come up next is Mary Ellen Pachowski. Mary Ellen does say she needs 15 minutes. It's going to have to be about 5. We have a lot of testimony.
Mr. Chairman, members of the committee, thank you for the opportunity to publicly address House Bills 4416 and 4419. My name is Brendan Boudreau. I'm the Director of Field Operations and Political Operations at the National Association for Gun Rights, a member-supported organization with over 75,000 active members here in the state of Michigan. Today, the committee is hearing comments on this legislation, which is also commonly referred to as constitutional carry around the country. Before I forget, just wanted to let you know that we do have over 10,000 petitions from our membership here in Michigan in support of constitutional carry legislation. On behalf of the National Association for Gun Rights and our members here in Michigan, as well as our state affiliate, Great Lakes Gun Rights, I speak in support of House Bills 4416, through 4419, but would also encourage the committee to further improve this legislation with recommendations that I'll cover later in my testimony. First, I'd like to discuss the concept of constitutional carry. At the heart of these measures is the idea that the Second Amendment rights and the rights protected in Article 1, Section 6 of the Michigan Constitution, along with our right to self-defense, should not be subject to the whims of the state. The concept of constitutional carry legislation is quite simple. Constitutional carry laws recognize the right of every law-abiding citizen to carry a firearm, openly or concealed, on their person without having to receive government permission in the form of a mandatory state or county-issued permit. Unlicensed open carry is already legal in Michigan, and forcing law-abiding citizens to purchase a concealed pistol license amounts to little more than a coat tax on covering up your firearm in public. By rendering the concealed carry permit optional within the state of Michigan, this state will be joining 12 others, which is more than a fifth of the country at this point. The National Association for Gun Rights has fought hard to pass constitutional carry across the country, and will continue to fight in Michigan until it becomes a law here. Critics of constitutional carry often argue that Wild West shootouts will spill out into the streets simply because concealed carry permit is rendered optional. Yet there is no evidence for this. In fact, all evidence points in the opposite direction of this outrageous claim. According to FBI crime statistics, states which have passed constitutional carry into law have both lower violent rates and lower murder rates by firearms than non-constitutional carry states. The same holds true with arguments regarding officer safety. While we proudly support law enforcement, the common claim that constitutional carry will put officers at risk has not been seen in constitutional carry states. In fact, evidence points to the contrary. Law-abiding citizens who are allowed to carry their firearm openly or concealed without government intrusion reduce crime, plain and simple. And if Michigan passes constitutional carry, it will also be recognizing another fundamental truth. The choice to wear a shirt or coat while in public over your legally owned firearm should not require government fees and licensing. Licenses should be optional for reciprocity purposes. To be clear, constitutional carry is a very simple concept. It doesn't allow anyone to carry a weapon that cannot legally possess one. Criminals will not suddenly be able to legally carry a gun. Those barred under the law from legally owning or carrying a gun will still be barred under these measures. The arguments that criminals will suddenly be emboldened to illegally carry guns because of constitutional carry is laughable, and there's no statistical evidence to back up these claims. This bill does nothing more than restore law-abiding gun owners the ability to lawfully possess a concealed firearm on their person while in public without having to pay a government fee to do so. To improve this bill package, I encourage the committee to amend this legislation so that CPL holders and those who would be carrying under the constitutional carry law would have equal rights as to where they are allowed to carry. House Bill 4565 and House Bill 4568 and the bill package being led by Representative Gary Glenn do a good job of bringing more equality between CPL holders and non-CPL holders. Also, I encourage the committee to clean up MCL 28422, as HB 4568 does, to make it clear that the permit to purchase is not required to carry, possess, or transport a firearm in the state of Michigan.
We got to stick to this particular bill, so, and we're going to
Understand.
probably have questions, so.
Understand.
Is that the end of the testimony?
Yes, sir.
Okay.
Thank you for your time.
Thank you. Representative Grimel.
Thank you for your testimony. Currently, if a police officer comes across someone who is carrying a concealed weapon, it's very easy for that police officer, for he or she, to determine whether or not that person is legally authorized to carry the concealed weapon. They simply have to determine if the person has a permit or not. Given that there are a number of crimes that disqualify people from legally being able to carry a concealed weapon, while other crimes don't, how do you expect or anticipate that law enforcement personnel would, if these laws were to pass, or these bills were to pass, how would they determine whether or not somebody is legally qualified to carry a concealed weapon if the police officer comes across a concealed firearm in the absence of a permitting process?
Mr. Chairman, Representative, I would ask, how do they currently do it for open carry?
Well, they don't, and I would argue that might be a problem. But I'm asking you how they will do it for concealed carry if these bills pass.
I would point back to my original question, how do they currently do it for open carry? What we're saying here is treating open carry and concealed carry equally under the law. As Representative Hotanga pointed out earlier in her testimony, we're talking about the difference between wearing a coat and not wearing a coat.
Well, it sounds like you agree that there's really no good way to enforce the prohibitions on concealed carry if these bills pass, because there's no easy, simple way for a law enforcement officer to determine whether or not the person is allowed under the law to carry a concealed firearm or not when they encounter a concealed firearm, because that's really the current state when it comes to open carry.
Mr. Lambert informs me that what law enforcement currently does for open carry would be the same that they would do under the constitutional carry law, which would be check lean.
Yeah, except my point is this: if you check lean on somebody in the absence of a permit requirement, all that comes up is all the offenses that they've been convicted of. It doesn't indicate which of those offenses disqualify someone from carrying a concealed firearm.
Mr. Chairman, I don't have a response to that. My point stands that what we're talking about here in the state of Michigan is treating open carry and concealed carry the same. The CPL in the state of Michigan is nothing but a coat tax. As Representative Hotanga and several other members have testified here today, there are many good law-abiding citizens in the state of Michigan who are getting hung up by Michigan's gun laws just for wearing a coat or accidentally concealing their weapon or not realizing that it's against the law to carry your handgun in your vehicle without a CPL.
Thank you. Representative Lefebvre.
Thank you so much for your testimony. Are you familiar with a Supreme Court ruling that states that an individual open carrying may not be stopped by police for the sole purpose of detaining them because they're open carrying?
Mr. Chairman, to Representative Lefebvre, I do know that Indiana Supreme Court just made that ruling. I'm not familiar with it being at the federal level or at the state level. Mr. Lambert might know better.
Indiana Supreme Court based on federal rulings.
Thank you. Any other questions for Mr. Boju? If not, thank you so much
Thank you,
for your
Mr. Chairman,
testimony.
members.
Next, we have Mary and Alan Polowski of Ultimate Protection Academy Range, and they oppose the bill. Again, you're looking at about a 5-minute time period. We're ready to go.
Thank you to all the committee and state representatives for allowing us to be here today, especially to the Honorable Mary Robinson and Honorable Bill Sowerby, who took time to return our call to discuss these bills. We are Mary and Al Polkowski, owners and trainers for 22 years of the Ultimate Protection Academy Indoor Lead-Free Range in Clinton Township, Michigan. To save time for other testimonies, we will remind the committee that you have been receiving and have received at this point 62 pages of biography vita and detailed explanation of our opposition to constitutional carry in the packages of House Bills 4416 through 19. As life members of the NRA, members of NCRGO, and most importantly, because of Mary Polkowski, my wife sitting next to me, regular testimony in favor of Public Act 381 from 1995 to 2000, Michigan's original concealed carry law, it passed in December 2000. Public Act 381 passed 17 years ago primarily because of the articulated and comprehensive pistol safety course requirements a concealed pistol license applicant must pass to continue the application process. Our master instructor and good friend Masada Yu, a man much more accomplished than us in all things use of force and firearms, has stated in his Use of Force, Lethal Force Institute lecture that says, and I quote, "No, you do not have a God-given right to discharge your firearm for protection when your kids and my kids are the backstop to your bullets, unless you have proven to someone your bullets will hit their mark." Continuing on, John Farnham, world-renowned firearms trainer, author, and also our good friend, has agreed with us. 95% of all firearm owners have no interest in advanced training beyond what is mandated by law. We would add that, however, 99% of that group who have successfully passed our state-mandated pistol safety course have stated to us that they realize the value and the necessity of the training course. Sadly, uninformed persons may accuse firearm instructors, including us, as only interested in concealed pistol license status quo for financial gain. Nothing could be further from the truth. Mary Nell Polkowski challenged anyone in this hearing to even come close to the hours and efforts my wife and I have volunteered for at no cost, safety training for which, including multiple awards, are listed in our 47-page vita selected by biography sent to each committee member as of this date. Please note that Mary Polkowski's gun rights group, Ultimate Ladies Club, and now Mary's Angels, from 1995 to 2017, has never charged for membership, as it is free with no paid advertising or paid administrative staff. The founders of MCRGO, before MCRGO was formed, were members for free. They were attorney Ross Steichman, Ron Collins, and our student Pat Alzadi. We want to be positive and help sponsors change these bills to improve the safety of all Michiganders. Let's figure out how to do that. Number one, set up an instructor approval list at each county clerk. Provide clear and concise enforcement to weed out instructors who refuse to comply with the pistol safety course requirements in its entirety. Number three, to provide for both CPL holders and instructors to annually pass the minimum MCOLS, police pistol annual qualifications, in order for, and I say from, this is an important document that you have received already, as Ohio Police Officer, Ohio Police Academy Adjunct Instructor Greg Elfritz says, at least CPL instructors should, and their applicants, at least be as competent with their firearms in public as the officers who patrol the streets. Number four, if fees are the issue, and we've been hearing that throughout this testimony, then reduce and remove CPL fees as reduction of government services and streamlining of the application process is apparent in the past years. For example, review of training application and their applicants no longer require fingerprinting. Also, Wayne County process has streamlined their application for CPL by assisting their processing with Wayne County Sheriff Reserves, who volunteer their time to do the processing. Almost all counties process online with photos being imported from the Secretary of State. However, instructors have realized about a 50% on average or more drop in fees charged since 2001, yet requirements for the training has remained the same. Let's take a look at the CPL state fees and county fees. They remain the same in 2016 years later. If we want to do something, let's change the fees from the state or not have any fees at all. I will also stay here, very importantly, in conclusion, in May of 2010, my wife and I, at our own expense, sponsored a gun rights forum of which State Representative Ken Metzer, the BATF, were invited, as well as Michigan Open Carry. It was at our location. We provided free food and refreshments. And at the end of each speaking opportunity, Michigan Open Carry passed out brochures. And I will read from their brochure.
We're well over the 5-minute time
I
period.
just got this last few statements, I'm done.
Oh, okay.
If I may,
Go
Chairman.
ahead.
They stated in their brochure, Open Carry, Advisory note, before carrying a handgun, we recommend that you become familiar with all state and federal laws in regards to firearm laws and the use of deadly force. Note, taking a self-defense/firearm course is recommended. Thank you for the Michigan Open Carry for agreeing with us on this importance of training and firearm law education. Thank you very much.
Thank you. Any questions from the committee? If not, thank you very much for your testimony. Next, we have Joel Fulton of Freedom Firearms South Sportsman's Club speaking in support of the bill. And on deck, we have David Dudenhofer of Michigan Campaign for Liberty after Joel.
Thanks for the heads up, Mr. Chair.
Well, yeah, I got to make sure I'm keeping in line here. You know, I think I'm going to hold off on David Dudenhofer, and after you have Sherry Mason of Brady Campaign and Anna Fisher representing herself. So those two are on deck. Go ahead.
Mr. Chair, committee members, thank you very much for considering these packages. I believe there can be no greater calling for an elected representative to expand freedom for citizens and a responsible approach to creating good public policy. As one of the most prolific and well-respected CPL instructors in this state, I wanted to reach out to you guys on this matter. I've trained over 12,000 students in the last 15 years. Also 118 instructors. I've trained students from 59 out of Michigan's 83 counties. I am a life member of the National Rifle Association, Second Amendment Foundation, Michigan Open Carry, Michigan Coalition of Responsible Gun Owners, and a member of Michigan Gun Owners. Most recently, we ran into each other on the Capitol steps, Mr. Chair, and it was great to have you there. I also have worked on reciprocity. The whole reason that Michigan has reciprocity with 40 out of 50 states is because I worked on that project voluntarily with first Attorney General Mike Cox and then subsequently Attorney General Bill Schuette. During that time, I had the privilege of studying the laws of the 50 other various states in securing those reciprocity agreements. As noted earlier, many states have no training requirement whatsoever, specifically our neighboring state of Indiana, where folks who are 18 years of age can obtain a permit with no training at all whatsoever, $25 permit fee, and they can then carry into Michigan with no duty to disclose whatsoever. Okay? And we don't have any problems. Indiana doesn't have problems in their state, and we don't have any problems with them coming into our state. It hasn't manifested itself. There are now 13 states that have no requirement to obtain a license to carry a handgun as long as you're legally able to possess a firearm. Those include the constitutional carry states. There's also other states that have no mandatory training requirement before obtaining a permit to carry. Those include Alabama, Georgia, Hawaii, Indiana, New Jersey, New York, Pennsylvania, South Dakota, and the state of Washington. Some of those states very, very liberal. In fact, New York requires no training and a $10 permit. That's it. Okay? So the truth is, people who are unfamiliar with firearms want training. I see it every day in my firearms shop. I'm not only an instructor, I'm a federal firearms license dealer, and I also serve on Berry County Sheriff's Auxiliary. So in several capacities, I understand this law all the way around. Those people who do not have familiarity with firearms want training. They don't want to have a deadly firearm and a deadly weapon in their possession without knowing how to use it. They understand it's a danger to themselves and a danger to others if they don't have that knowledge. And they beg me for training, of which we provide it for them. We want those citizens trained. Okay, there's no question about that. Well, I can understand on the surface the comfort level of police officers, for instance, wanting citizens to offer them the courtesy to let them know they have a firearm present during a stop. It does present several problems. Okay? We mentioned, in Representative LaFave, you've brought it out quite frequently so far. Let me give you a real example. Somebody driving through Ann Arbor, and I'll let you know, University of Michigan campus covers most of Ann Arbor. You can be driving down what you believe to be a public street and you are on campus property. Because this government, House and Senate, have refused to force universities under Michigan's preemption law for firearms. They have made their own rules about firearms on their campus. So if I get pulled over for some minor traffic infraction on the University of Michigan property, I am then bound by my CPL license to disclose that I have a firearm on my person. I have now admitted to a crime, and I now get arrested for having a firearm on campus. And I was forced to give up my constitutional right against self-incrimination. I believe currently you have an unenforceable phrase in your current CPL law because of that. Secondly, disclosure creates a false sense of security, and if our officers are honestly relying on that, they're already putting themselves in danger of being killed. Every encounter should be dealt with as a deadly force encounter until such time as you have determined through interaction and behavior that you believe you can trust that citizen that you have in front of you. Otherwise, you're letting your guard down. And I don't believe that any of our officers are going to do that. Furthermore, anybody from out of state is not required to disclose, as we already know under our law. And one of the main reasons for that is because if they did and they were in 1,000 feet of a gun-free school zone, they'd be violating federal law because they don't have a permit from this state. And that would be a federal offense. As far as duty to disclose, just in short, I could name off the states, but there's only 10 states that have a duty to disclose out of 50. We would be the vast minority of those states. As to the question of how law enforcement would be informed if a citizen became statutorily disqualified, that's been hit several times, and it's in the lien system. The same requirements for openly carrying, those same disqualifiers would be disqualifiers now for permitless concealed carry, and those are pretty easy. Look, law enforcement's not stupid. They'll have that figured out real fast. They'll be able to look at lien, and we can tell whether somebody is statutorily disqualified from possessing a firearm based on their convictions. I would care not to insult the intelligence of our officers on the street. They know these things. The biggest thing that I have, I guess, that I want to add to this conversation is the institution of concealed carry in the first place. It started clear back 90 years ago, in fact, over 90 years ago. And if you understand the history of it, you would be appalled. What happened is we had an industrial revolution in this state. Our economy was moving due to a guy named Henry Ford developing the assembly line. And what happened is we had people come up from the South, and with that came a different demographic that we weren't comfortable with. And because we weren't comfortable with them, we established laws that prevented them from being able to obtain firearms and concealed carry permits, specifically black people. And we did it, and it was a racist institution. Now, maybe later on we used it for good, but any institution founded on racism, if you continue it and perpetuate it, it's continuing to perpetuate institutional racism. You're disadvantaging the poor, you're disadvantaging minorities. I have people that live paycheck to paycheck. You said it shouldn't be that much of a burden, Representative Greimel. Well, I'm talking about $325 divided by $7 an hour. That's 46 and a half hours of work for somebody that's living paycheck to paycheck to try and obtain the training and a permit.
We have to get to questions. Do we have any questions for our presenter? Yes, Representative Greimel.
Yeah, thanks for your testimony. I'm looking at the Attorney General's website right now, and it may be inaccurate, so I haven't verified the information on it. But according to Attorney General Bill Schuette's website, those who have concealed carry permits from other states do have to disclose to law enforcement while they're traveling through Michigan.
I would say that the Attorney General's website is inaccurate in that regard, because the specific section that was referred to earlier by my colleague Tom Lambert is section 28.425F, and it says licensed under this act. Anybody from outside the state is not licensed under this act. They're licensed under the act of their state.
I'll take a look at that.
Thank you, and thank you for your testimony.
Thank you very much.
Next, we have Sherry Mason from the Brady campaign and Anna Fisher representing herself. Welcome. Go ahead whenever you're ready.
Thank you for this opportunity to speak today. People who have spoken against this particular bill have been probably far more articulate than I am going to be on the subject. I'm going to speak very broadly, but from the heart. Firearms are one of the only products made for the purpose of killing. This fact alone, I believe, should be enough to require all firearms be held to the very highest level of product safety, regulation, and training ownership. In fact, the idea that lawmakers wouldn't be doing everything in their power to raise the bar for firearms ownership and public safety seems at best negligent, and for the victims of gun violence, it's a complete betrayal by their elected officials. With over 30,000 gun deaths each year, and the public opinion in favor of expanded background checks, the idea that this or any governing body would be poised to make it easier to carry a gun around would be laughable if it wasn't tragic. I've been in the gun violence prevention movement since 1999, and I'm very familiar with the mantra used by the gun lobby whenever new gun legislation is presented. We don't need new laws. We just need to enforce the laws that are already in existence. But apparently that isn't enough. We have a CPL permit process that provides a layer of protection to our citizens, but instead of raising the bar and bringing the open carry bill to the same level of protection, we want to lower it. And I think that we need to enforce the law that is on the books and not shift this position and not ignore the facts. I do believe it's confusing, but why not raise the bar? Why lower it? It seems like we're ignoring fact. And there are, as I said, there are a lot of people here that are bringing facts from different resources. But a few of the facts that I'm aware of that I'd like to present. The homicide rate has fallen sharply in the last 50 years. Yet, the prevailing feeling is that we really need to have our guns on us at all times anywhere we go to protect ourselves from evidently a very dangerous society that's out there. There's also this fact that we know most guns occur as a result of suicide, not bad guys breaking into our homes or mass school shootings. Yet here we are, arguing whether or not we should make it easier for citizens to carry their firearms into places where they might fall into the hands of children or people who might be a danger to themselves or others. At least people with the CPL permit as it stands now have had some safety training. And they're law-abiding citizens until they're not. States with the highest gun ownership also have the highest rates of deaths, another fact. Yet here we are today considering peeling off another layer of protection by eliminating the CPL permit, potentially increasing the number of guns in the civilian population. We know another fact. We know that 87% of firearm deaths of children take place in the home, and 82% of firearms used in suicides by kids under 18 are owned by their parents or a family member. Yet here we are, considering a way to make it easier to carry those same guns, those guns owned by law-abiding citizens, out into public places where they can be misplaced or stolen. Study after study has shown that gun laws work. The Journal of American Medical Association and Internal Medicine, Harvard Injury Control Research Center, and Georgetown University, just to name a few, have shown that states with strictest gun laws have fewer gun deaths. Yet, here we are, another case of Michigan's race to the bottom. Instead of working together to make our state a leader in preventing gun violence, we're doing our best to ignore real facts about firearm ownership and use. Why must we bow to this alternative universe based on the vision of everyone wearing a gun on their hip, ready to pick off a bad guy at a moment's notice? I don't believe that this scenario is grounded in reality or facts, but rather a Hollywood fantasy promoted by the gun lobby and its irrational fear-based marketing.
You're going to have to get
I'm just
wrap it up
about
here.
done. Many in the room today have a different fantasy and kind of a dream of living in a state where it's elected officials who, instead of spending their time, energy, and our tax dollars weakening gun laws based on alternative facts, would work together to make strict gun laws based on real facts that would keep guns out of the hands of people who shouldn't have them. Thank you.
Thank you. And Ms. Fisher?
Out of respect for time, I'm going to pass. Sherry has expressed my sentiments very well.
Thank you very much. Any questions from the committee? Yes, Representative Guerra. Well, the one, Ms. Fisher was representing herself.
The you treat the individuals that are opposed to the bill in the same way that those that are in support of the bill. So now this is the second time they've doubled up on those that are opposed, which doesn't leave 5 minutes for this other individual, although she did, concede that she doesn't need them. But I just think they've made the trip down here. The least that they could do is testify on their own.
We're trying to go back and forth, but we have a lot more on the opposed that are speaking.
On the other side, you didn't double up the other individuals who are opposed to the bill. And so if that is the case, in the interest of time, then I would ask that you double up on those that are testifying in opposition to the bill, or in support of the
actually
bill.
have more in the opposition, so in the interest of time, we're having to double up in some cases. But I'm giving everybody their required amount of time. Thank you very much. Next, we have David Dudenhofer of the Michigan Campaign for Liberty. Is he not here? I don't see Mr. Dudenhofer, so next we will have Steve Doolin and Brady Schingener of MCRGO. And on deck, we will have from Voices of Peace, there's 2 individuals from Voices of Peace, Susan Callahan and Susan Harris, from 2 individuals from Voices of Peace. So yes, go right ahead.
I am Brady Schickinger, the Executive Director of the Michigan Coalition for Responsible Gun Owners. Steve, who's our attorney, had to head back to his law office. He's not going to be here to testify, and I'll try to keep it short. Prior to being the executive director of MCRGO, I was a House staffer, actually a House Democratic staffer for 15 years. And one of the things we were constantly reminding ourselves in the House when we worked on legislation is we don't exist in a vacuum. Michigan is one of 50 other states. And what we do here has been replicated already and will be replicated in the future by other states. We have 13 other states that have already passed some form of permitless concealed carry. And we can look to those states and see what the results are going to be of passing constitutional carry here in Michigan. And when we first started the discussion of constitutional carry here in Michigan, some of our members had concerns about the issue of training. So we started contacting states that had already passed constitutional concealed carry, states like Arizona that adopted it in 2010, and asked them what their experience was. And to our surprise, what we kept hearing from instructors in other state organizations in those states is rather than the number of people seeking training going down, the number of people seeking training actually started to go up. In some states it actually spiked. And we ask ourselves, well, why is this happening? If we're not mandating training anymore, why are more people getting training than before we required it? And what we found out from those other states is that when you remove the licensing process with the cost of licensing, what happens is a greater number of people that are gun owners at home become interested in carrying outside the home for self-defense, exercising their constitutional right to bear arms, essentially. And those people, once they start carrying, what they discover in states like Arizona and what they'll discover in states like Michigan is without a CPL, their ability to carry outside the home is much more restricted than it is with the CPL. And I know Tom Lambert from Michigan Open Carry touched on that briefly. For example, a Michigander, supposing this bill were to pass today, or and pass the Senate 2 weeks from now and be signed in law by the governor, Michigander without a CPL who can carry concealed in Michigan isn't going to be able to go to Ohio and carry concealed. That's something only a CPL holder can do. There's also a wide range of locations that that person without a CPL isn't going to be able to carry concealed. For example, they can't carry in almost any place with a liquor license. So beyond bars, they're not going to be able to carry in most restaurants. They're not going to be able to carry in pharmacies that have liquor licenses, which is any Rite Aid or CVS. They're not going to be able to carry in Meijer or most grocery stores, any party store, any gas station that sells beer and wine. All those places will legally be off limits to a CPL holder, or I mean a person without a CPL, somebody carrying concealed without a license. So the natural response for those people, once they start exploring carry outside the home, is to say to themselves, well, hey, I actually need to get a CPL, and then that population ends up going to get training. And this shouldn't come as a surprise to us in Michigan. Open carry in Michigan has never required, there's never been a requirement for training or a license. Yet we know from talking to our allies that carry openly that the vast majority of them have their CPL. It's for the same reasons. So when we started going to those other states and asking what their results had been with constitutional concealed carry, when we found out more people are actually getting training than before, and we can see their crime rates dropping, we said to ourselves, well, this is a no-brainer. Based on those experiences in the other states, Michigan should be following the same pattern. And what we recognize is that these bills lead to a safer state, and they lead to more responsible gun ownership in the state. And our board voted unanimously to strongly support these bills.
Thank you. Any questions from the committee? Representative Grimel.
Yeah, thank you for your testimony. So as I understand it, your explanation as to why in some states that have passed permitless carry, that training has increased, is that more people are carrying concealed firearms in those states. And it seems to me that the relevant question that is not what the total number of people going through training is versus the total number of people not going through training, but rather the percentage of people who are carrying concealed who have gone through training. And it seems to me that it's not clear, based on what you've said at least, whether that percentage has increased in these other states or whether that percentage has declined in these other states that do not require it in order to carry concealed. Do you have any statistics on that question?
I don't. Steve, our attorney, once he got back to his law office, submitted testimony to me to turn into the clerk in a written form. And I'll get that to you. I think some of those numbers are in there. I don't have those numbers on me today.
Well, while we're on the subject, Mr. Chair, of training, I do just want to note, I think we heard some earlier testimony that indicated or suggested that the current training requirements, firearms requirements for CPLs is greater than that of law enforcement officials. And I do just want to clarify the record that those officers who are MCOL certified must receive 86 hours of firearms training. Every Michigan Police Academy requires at least 100 hours of firearms training. I think the lower requirement that was mentioned for law officers is an annual requirement on an ongoing basis beyond the initial quite substantial firearms training that's required. Now, I know that you have a policy background here in the state legislature. Is that your understanding as well, that law officers go through very rigorous training?
I'm not aware what the MCOL's training requirements are for law enforcement officers. I do know that the disqualifiers to get a concealed pistol license in Michigan are greater than the disqualifiers to become a law enforcement officer in Michigan. Of course, those two sections of laws were written independently of each other, and they were written at different times. So.
Okay, any other questions? Apparently not. Thank you very much. We have two individuals from Voices of Peace, Susan Callahan and Susan Harris. They have left? Okay, then we have Linda Bronig of the Michigan Coalition to Prevent Gun Violence. And again, for the Michigan Coalition to Prevent Gun Violence, we have Lynn Bartley. Welcome.
Thank you. It's Linda Brundage, Dr. Linda Brundage. And I appreciate the opportunity to address the committee this afternoon. Oh, thanks. Linda Brundage. I appreciate the opportunity to address the committee this afternoon. I'm with the Michigan Coalition to Prevent Gun Violence. And I'm motivated to do this work as a mother, a grandmother, a psychologist, and a person of faith. I want to contextualize the work that we're trying to do here today. In Michigan, in the month of May, just in the month of May, there have been 57 different shooting incidences. As of this morning, there have been over 22,572 total incidents of shooting in the U.S., 5,525 deaths, 231 children killed or injured, 1,150 teens killed or injured, 126 mass shootings. These numbers come from the National Gun Violence Archive, and they do not represent the 22,000 plus number of deaths by gun from suicide. Just one more statistical piece of information. The total number of Americans killed by gunfire in 2015 was 36,252. I appreciate your patience as I share some numbers and statistics with you, and I urge you to hear these numbers as numbers with the tears washed off. Michigan currently has more deaths from guns than automobile deaths. And we should be about the work of trying to prevent gun deaths, not add to the likelihood of more deaths by firearms. Under this proposed legislation, our state would have little means of keeping guns out of the hands of felons, domestic abusers, and others who are dangerous and would create a real risk to Michigan communities. Bypassing the permit process and giving a gun to a person who may never have fired one before, who doesn't know what the law is for use of deadly force, or maybe not had a background check, is a recipe for tragedy. The current permitting process in Michigan has resulted, as of May 1st, the current permitting process in 16,000 plus applicants being disqualified, 4,000 plus licenses revoked, over 2,500 suspended. These are Michigan State Police data, and they're available by county if you want to look up your jurisdiction. What we do know from research is that more guns equal more death. Kristen Rand of the Violence Policy Center tells us that the evidence could not be more compelling that states with fewer guns and strong laws have a far lower incidence of gun death. Gun violence is a major public health issue, and it is a threat that demands immediate attention from policymakers here and nationwide. Here in Michigan, we should be addressing the likelihood of death or injury by firearms, not trying to make it possible for more people to easily access guns and carry them loaded and concealed.
Okay, you're going to have to kind of wrap it up. We're well past 5 minutes.
I'm working on it. Easy access to lethal means makes it more likely that a child will unintentionally access a firearm with life-changing consequences. A teen may be showing off and kill himself or herself or commit suicide. We know that when a gun is present in a home, a domestic violence situation, a woman is 5 times more likely to be killed. Rather than weakening Michigan gun laws should be about protecting our citizens. I'm assuming that the representatives who have proposed this legislation are gun owners, so I want to share some very current April 2017 from the Americans for Responsible Solutions. We should be here today talking about getting universal background checks, which 80% of gun owners support. There's been a lot said about the Second Amendment, and I want to speak to that as well. The U.S. Supreme Court's 2006 decision in the District of Columbia v. Heller provides good policy guidance on gun ownership rights and public safety. Justice Scalia wrote this opinion with great care. First, the court confirmed the right of individuals to possess firearms for traditional, lawful purposes such as self-defense within the home and for hunting. Second, the opinion also held that Second Amendment rights are not unlimited. Justice Scalia went out of his way to declare long-standing laws designed to protect the public are valuable, are enforceable. We cannot let gun owner convenience drive firearm policy in Michigan.
Okay, we got
Two sentences here. A jacket over or under a gun is not what is at stake here, or a gun in a purse. Michiganders do not want people who have never shot a gun, learned the existing laws of Michigan, or had any firearms training to be carrying a loaded, concealed gun in public. I am speaking in total opposition to HB 4416, and I urge you to vote against this legislation. Thank you for your time.
Thank you. Any questions from the committee? Apparently not, so thank you very much for your time.
Thank you.
Hi, my name is Lynn Bartley,
This is
and
Lynn
I
Bartley.
am a member of the Michigan Coalition to Prevent Gun Violence. I'm also an educator, and I'm also speaking as a citizen of Michigan. I oppose this bill. Please consider the following points. Michigan needs laws that make our children safer, not laws that make carrying a concealed, loaded gun easier. HB 4416 would increase the number of concealed, loaded guns on our streets. Many could be in the possession, as we've been just talking, of people who are untrained, without a permit, and very likely without a background check. It makes sense that many currently untrained gun owners without a permit would carry a concealed gun if this law was enacted, whereas they would not carry they would not openly carry today for whatever reasons. Therefore, this law would put more guns on our streets. As you've already heard, and I will not repeat a lot of the statistics, although they're very important, but you've already heard, research shows over and over that the more guns that are on our streets, the more gun-related deaths and injuries will occur. As a citizen, I am concerned that I will not know when untrained people without a permit and possibly with no background check are carrying a concealed weapon in close proximity to me and to others who I love. Whereas today, I know, I can see people who are openly carrying, and I can make the decision to leave, along with the children and other people who are with me. We can leave in our own effort to protect ourselves. But with this law, I would not know if someone who's untrained is standing right next to me, and I would not have the freedom then to know that and to protect my own life and those of the children and other adults who are with me. I believe that there are a lot of other people in Michigan who also would do as I do. I leave when I see somebody open carry. I've actually felt like leaving earlier today, but obviously this is important to talk to you. But I think other people also leave to protect themselves. Why be near someone who is carrying a gun? We don't know that person and how dangerous they could be. And then I think, and I hope you will, as you consider this bill, I think about putting this law alongside Michigan's already existing Stand Your Ground law, which allows people who feel threatened to shoot. Please protect our children and the citizens of Michigan. Please oppose this bill. Thank you very much.
Thank you. Any questions? Apparently not, so again, thank you for coming and thank you for your testimony. Next, we have Art Tom of the National Rifle Association, and we do have, we have heard from, but we didn't hear specifically from, we have two individuals from Physicians for Prevention of Gun Violence. Kathy Keller and Jerry Walden will be our last presentation. So with that, Art, Tom, go right ahead.
Mr. Chairman, members of the committee, again, my name is Art Tom, and I represent the nearly 160,000 Michigan members of the National Rifle Association. I come here today in strong support for House Bills 4416 through 19. I've distributed some handouts for all of you. Didn't really want to inundate you guys with an overload of information, but on a bill such as this, I felt it was pertinent for you guys to have the actual factual information. As you'll see in the documents provided, with Michigan recognizing permits from any state in the union, there are literally hundreds of thousands of permits recognized by the state of Michigan from states that require zero training. Simple crime reports prove that not only is this not a realized threat in the issuing state, but is shown absolutely to have no negative impact on Michigan as well. I'd like to address some of the other concerns that we've heard today too. One, this bill changes absolutely nothing on who can and cannot possess a firearm in the state of Michigan. It changes nothing on who can possess a firearm in the state of Michigan. Duty to inform. That's a big hot topic across the country at different times. One of the things that needs to be made clear on duty to inform is that the only people that it affects is law-abiding gun owners, period. Anybody that is in illegal possession of a firearm is already protected from telling the law enforcement officer that they're in illegal possession of a firearm. The Fifth Amendment protects them from doing so. Again, the only person duty to inform will ever have an effect on is the person that the law enforcement officer has absolutely no reason to fear already. It was mentioned about children finding a gun in the home and the unfortunate circumstances of a suicide or a negligent discharge in the home. It won't take you long, I hope, to realize in reading through the bill that this would change absolutely none of that unfortunate situation. When we talk about the concerns from 2001, that was brought up, and how there's going to be blood running through the streets if we do this, and more guns equal more crime. And if we go back to 2001 and do some research, which I've done, and I've handed each one of you pieces of press where folks had said that there were going to be blood in the streets. We heard that gun-toting, trigger-happy citizens were going to be we were going to be letting them loose in the streets, and the gun crime that was going to be coming from that, and how people were going to be dying because of the shall issue concealed carry law. And not only has that not happened, but actually the exact opposite has happened, and Michigan is at an all-time low in crime. In fact, one of the biggest opponents to that law, Chief Michael Martin, who's the co-chair of the Legislation Committee for Michigan Association of Chiefs of Police, was quoted after that saying, "I think the general consensus out there from law enforcement is that things are not as bad as we expected it could be." It just didn't happen. The prescription for gun violence. 12 states already have this law without this issue. None of the concerns have come to fruition. It's not going to happen in Michigan. It's just not. Again, suicide, this isn't going to change who has access to a firearm and who can commit suicide this way or another. Michigan may want to look into a suicide prevention acts or something in that nature to assist with that. When we talk about victims of gun violence, and it was mentioned that this may allow people to become victims. The National Rifle Association and our 180,000 members here in the state of Michigan believe just the opposite, that this kind of law prevents people from being victims. What better way to prevent someone from being a victim than to enable them to protect themselves? There was a statement made that law-abiding gun owners are law-abiding until they're not. Forgive me, but under that mentality, all rapists, men, should be castrated at puberty. Because, well, we have the opportunity, don't we? I'm not here to debate the fallacy that is the fabricated facts from former Mayor Bloomberg's gun groups that talk about 126 mass shootings. But I challenge anyone on this committee, anyone in this room, anyone in this state and in this country to find and to bring to me the factual data that where we can agree that there were actually 126 mass shootings. It just hasn't happened. And when we talk about more guns equal more crime, and the gun lobby coming in here and saying that's absolutely not true, and all of our fabricated details, and how more guns make us safer, the arguments that we're all tired of hearing, including myself, I ask you to look in that packet that I gave you and pick out the paper from the National Safety Council. Understand, that's not the National Rifle Association, that's the National Safety Council, which shows that since in 1999, firearm deaths, or firearm unintentional injury-related deaths were at 824. In 15, they were 489. That's from 06 to 15, a 24% decrease, 17% in the last, from 14 to 15. I'm pretty sure that the media hasn't hidden from us, especially over the last several years, that gun ownership is at an all-time high. Month after month, we break records on purchases of firearms. All-time high gun ownership, all-time low gun deaths.
Okay, you'll have to wrap it up.
Yes, sir. Again, I implore you to support this bill. In the states that have already passed this legislation, none of the concerns that are brought today have been realized. The same, again, will be realized here in Michigan. I stand for any questions from the committee.
Thank you. Representative Greimel.
Yeah, thank you for your testimony. I think your earlier statement is certainly accurate when you say that this legislation would not change who can buy or own a handgun or firearm. I think that's accurate. I haven't heard anybody say anything to the contrary of that. I think the question is, does it expand the number of people who have been convicted of some crimes who can legally carry a firearm in a concealed manner? And we've heard testimony that yes, if these bills pass, it will allow some people who currently cannot obtain a CPL because of certain criminal convictions to, if these bills pass, legally carry a concealed gun. You agree with that statement, I assume?
My position on that is it changes nothing about who can possess and carry a firearm. Again, as it was stated earlier, you can openly carry a firearm under the current law, even under the circumstances you speak of. This would change nothing to that. I struggle to find the understanding that putting a coat on makes that person that much considerably more dangerous. I can't come to a place of common sense on that. That if they are allowed to conceal carry where they are exempt from a permit, and one of the things that may be needed to understand when it comes to under the permit system and what's the differences there is that currently under the permit system you can have reciprocity with other states, as previously mentioned, 40 states. You can have a NICS bypass So when you're purchasing a firearm, you don't have to go through the background exemption, you show your permit. There's, you can go on different places that have gun-free, that are otherwise gun-free zones. These are instances that those people are not allowed to take part in. But yet they're still allowed to carry a loaded firearm for self-protection on and about their person, just in an open fashion. To say, sir, that there's putting a coat on makes that person considerably more dangerous, I just don't agree.
Well, I'm just asking a simple question. Would this legislation allow people who currently cannot legally obtain a CPL to legally carry a concealed firearm? I think the answer to that is yes.
It is yes.
Okay. Now, in regard to the training question, I also think your observation is fair that this doesn't have an impact on who can own a gun in their home. So in terms of the I think, valid concern about accidents in the home, this legislation presumably would not increase the risk of that. I think that's a fair observation that you've made. But as you also pointed out, and I think accurately, the point in allowing people to carry concealed firearms is for self-protection in the public. And I think that's a valid concern. I think it's a valid right. I think people do have a right to self-protection. But what we're really talking about here is whether or not people who carry a concealed firearm in public for the purpose of self-protection should be required to go through a training course. And I think that it's precisely because people carrying concealed firearms are doing so that under certain circumstances they can defend themselves, that it's important for those individuals to go through a training program so that they know how to properly defend themselves, to defend themselves in a way that's as safe as possible for those who are in the general vicinity, and so that they know when it's legally justified to use deadly force to defend themselves and when it's not. And so I would argue that training is of paramount importance in the context of concealed firearms precisely because people are carrying concealed firearms for the purpose of self-defense. Do you disagree with that?
Sir, I am a certified instructor by the same organization that is my employer. And I, as well as the National Rifle Association, certainly recommend that any gun owner embark into a training program. One, because you get to learn about your firearm. Two, because it's fun. But to say that the government should mandate it, no, sir, I don't agree. And luckily, for all of us across the country, the studies have proven, even to some groups like Harvard, who are not necessarily a fan of firearms, that training has absolutely no benefit nor detriment to negligent or unintentional discharges. It has not led in any of the states that don't have any training requirements to an increase in unintentional homicides or any of that nature. It just hasn't happened. And Michigan already currently, as recognizing permits from any state across the union, allows those people on a daily basis, hundreds of thousands of those people, to carry in this state without training whatsoever. That we say is okay, but if you're a Michigander, it's just not okay. I don't understand why it should be okay for someone who's a non-resident of the state of Michigan to be able to do what someone here in the state of Michigan cannot.
My last question is it your perspective that the Second Amendment guarantees a right to individuals to carry concealed firearms without obtaining a permit?
I believe I believe that we have a God-given right to be able to protect ourselves in any means necessary when the situation would unfortunately present itself. Due to the nature of open carry, which I also support and do at times myself, and given in testimony by the mom that spoke here earlier that said that if she sees an open carrier she wants to beat feet the other way. Given the opportunity that if someone were open carrying a firearm for personal protection and a bad guy were to walk into the store with intent to cause serious bodily injury or death or rob the place, and they see someone with an openly carried firearm for self-defense, that person would become an immediate target. Sir, yes, I do believe that you should be able to constitutionally carry a concealed firearm for self-protection.
That, without a permit, is the question.
Yes, sir. I believe that anybody that's not otherwise permitted or otherwise prohibited from possessing a firearm, and again, I say someone that is not otherwise prohibited from possessing a firearm, should be able to do so in any manner that they see fit to protect themselves, should, again, the unfortunate need come arise.
Your stated position, the reason I ask is your stated position seems to be contrary to that as expressed by NRA attorney Paul Clement. In arguments before the Ninth Circuit, the NRA's attorney, again, Paul Clement, stated, and I quote, "I think that it's fairly clear that states should have the option about how they regulate carry. So if one state wants to prefer open carry and another state wants to impose concealed carry, they certainly have that option. They may also have options in how they go about their licensing regimes, whether they require training courses, longer training courses, and the like." So I'm curious as to what the NRA's actual position is on this, I think, very important core question as to whether there really is a constitutional right to carry concealed firearms without any training whatsoever.
Sir, I cannot speak to the attorney in question. I've actually, frankly, never met the gentleman. That said, I am the liaison for the National Rifle Association for the state of Michigan, and I do speak for the nearly 160,000 members of the NRA here in Michigan, that we support this bill strongly, and we consider it critical legislation here in the state of Michigan.
Any other questions from the committee? If not, thank you very much for your testimony.
Thank you, sir.
And next we have for Physicians to Prevent Gun Violence, Jerry Walden and Kathy Keller. Begin whenever you're ready.
Sure. Thank you very much, honored representatives. My name is Kathy Keller. I'm a family practice physician with 25 years of experience in Mid and West Michigan. I'm currently an assisted professor at Michigan State University's College of Human Medicine in Grand Rapids. And I am a member of Physicians for Prevention of Gun Violence, as well as Moms Demand Action for Gun Sense in America. And I'm strongly opposed to this package of bills. I've known many patients and families negatively impacted by gun violence and the fear of gun violence. Permitless concealed carry will only increase these risks and increase the fear. If we look at this from a purely public health standpoint, in terms of accidental shootings, such as a child gaining access to a loaded, unlocked weapon and shooting themselves, or a friend or a family member, this is a national tragedy. If a prescription medication caused the number of injuries and deaths that are caused by accidental shootings, bluntly, there would be a public outcry. That medication would be taken off the market and analyzed in depth for safety and risks versus benefits. What we really need is more research, public education, and I believe that every gun owner should be licensed and required to take a safety class so they know how to safely store and use their weapon. The increasing casualness with which people purchase and handle firearms is of great concern to me. We require drivers to be licensed and learn safety. We need to recognize handguns for the safety hazard they present, especially if allowed to be carried concealed by persons without testing for or without screening for significant mental health issues and no training. This is a medical issue, it is a public health issue, and loosening safety regulations is in none of our best interests. Thank you.
Jerry Walden. I'm a retired family physician with 37 years in the Ann Arbor area and co-leader of the Physicians for the Prevention of Gun Violence. And I thank you for this time. So I've lost, I'm a former hunter. I had a lot of respect for guns. I enjoyed hunting, but guns, used in Shooting people is an issue that I think is way different. And we have 25 times the victims in this country that are in other countries and are a huge outlier. Each week, about 1,500 gunshot victims are admitted to U.S. hospitals, where the gunshot patients are expensive patients, often having a very long hospital stay. Someone's gone from usually being a healthy person to a long-term patient in that one moment of being shot. Gunshots ruin lives, are a serious cost. The cost is quite incredible. We haven't really focused on that today. It's $230 billion estimated in the country in a year, and much of that hospital cost is borne by Medicaid and Medicare. It's not borne by private insurance companies, as people might think, because of the long-term nature of these patients. So I was a medical expert, and I saw a lot of patients who were wheelchair-bound for the rest of their life after a shooting caused a back injury or similar. So I want to speak to this new bill. I think it's a dangerous bill. I think we're already the leader in gun deaths, our country. 80% of the gun deaths in Western countries happen right here. So my opponents often talk about the safety issues and that it isn't unsafe to have more people with concealed carry permits. We don't know. I don't think those statistics, in fact, we do know that physicians were disallowed at the NIH back in the early 2000s from having a budget that would allow us to maybe look at this. But we have a huge amount of suicides, over 20,000. We've talked about that before. A lot of those suicide is 50% are coming from guns. And many of the people talking about costs are probably not investing in gun safes, which are very expensive, and keeping their guns stored in a safe manner. I hope they're teaching that, but you know, the fact that we've got so many suicides in our country would disallow that. As we've talked, automobiles are no longer as important, so this is a huge public health issue. That's why we've now got 500 physicians in this state speaking against having looser gun laws and more guns. We know that women in domestic violence situations are 5 times more likely. We also know that there are only about 25% of the domestic violence abusers are known to the police. So 75% are out there able to get one of these concealed carry, well, able, since they don't have to have anything besides just the gun, they're able to carry. And so that gun is going to be more available. And finally, concealed carry is already more common. My brother here said, well, back in 2001. In 2001, we had 52,000 permits in this state. Now we have over 500,000, almost 10 times as many. 7% of the people in the state have permits now. So what is the problem? Why are we trying to make it even easier? The police are opposed to these laws in many states. In Wisconsin, the executive director said the current law provides minimal amount of training and serves the police and the community at large well. In Mississippi, the police chief said, we are a gun society and we recognize that, but should we be writing gun laws we should be writing gun laws that make us safer. Do you want an incident on your street to escalate, every incident on your street to escalate to acts of gun violence? And lastly, in Texas, the police chief said, you can't be the party of law and order and not listen to your police chiefs. I urge you, as my fellow physicians do, to oppose this law.
Thank you for your testimony. Any questions from the committee? Representative Lefebvre.
Thank you, Mr. Chairman. I have a a couple quick questions. Is it your opinion that more gun laws means more or less gun deaths?
More guns and weaker laws means more deaths, so better laws and fewer guns.
So the stronger the laws, the less gun deaths?
Yes,
Are you familiar with the gun laws in Chicago?
yes.
Would you agree
I
with
know that
me-
Chicago's got a problem, but I know that Chicago is, as part of the problem in Chicago is straw purchases from outside of Chicago.
But just...
And also, we know that 40% of the gun deaths are, in homicides, are coming from guns that are being purchased without going through a gun dealer.
But just, if you wouldn't mind following me.
Okay.
Chicago, you would admit, has the strongest anti-gun laws in the country, at least one of, right?
I don't know, but go ahead.
And we all know that the violent rate in Chicago is horrible, wouldn't you agree with me?
Yes. But
Now-
we're still talking that two-thirds of the gun deaths are coming from suicides, and then there's a significant portion that we're talking about coming from these accidental incidents. So the homicides are a whole nother problem, but we do need to be looking at that problem. We've got Detroit, Saginaw, and Flint are three of the biggest cities in the country from the state police in 2015. I think they were ranked in the top 5, actually, those 3 cities in the country. So yes, it's a big problem there.
So I also heard from you that you believe that to get a gun, you believe you should have to get a permit?
I believe there should be required training, absolutely, and that's part of the permit process, absolutely.
So you believe there should be training and a permit process. Do you believe that to exercise your Fifth Amendment right, you should get a permit or you should get some training?
We're talking about guns here today, and we're talking about this particular bill that we're talking
But
about.
just in general, to exercise your Fifth Amendment right, do you think you should get a permit or training?
I'm only talking about gun safety today.
But you believe to exercise your Second Amendment right, you should get a permit and training?
I do, yes.
Thank you, Mr. Chairman.
Thank you. Any other questions from the committee? Apparently there is not, so thank you again for your testimony. And we have a number of cards in support and opposition of this bill package, starting with Terry Link with Peace Education Center is opposed to the bill, doesn't want to speak. Nicole Beda, as an individual, is opposed to 4416, doesn't want to speak. Roger Lang supports the bill package. Opposing the bill package is Courtney Gordon as an individual. Opposing the bill is the Reverend Linda McDonald as an individual. Opposing the bill package is Jim Little as a business person, individual. Opposing the bill is Ellen Link of People of Michigan Who Care About Safety. We have 2 individuals from Million Mom March who oppose the bill, Catherine Ross and Lori Mizzle-Spillane. We have 2 individuals from Michigan Coalition to Prevent Gun Violence who oppose the bill, Gloria Thomas and Marcia Corrett, I believe that is. We have a number of individuals who are here from Moms Demand Action who oppose the bill. Rick Omelian, Erica Dzidiazek, I'm not being able to pronounce that correct, Katie C., Teresa Turner, Kathy Kanmimba, Elaine Smith, Elise Zenda, Linda Danners, Catherine Allen, Joe McGlue, Melinda Dickinson, Catherine Emily Durbin, and Michael Karen, and those were all Moms Against Action. We have in support of the bill, as an individual, Gregory O'Neill, G.R. Dennis, Patty O'Neill, and Eric Joseph Coggin. And with that, that concludes the testimony for today's committee, so we are adjourned.